Major breaking news. The Trump administration continues to do its job and continue to support and fulfill its promises when it comes to our Second Amendment rights. The first round of individuals who have had their Second Amendment rights restored, that list, as required by law, is being published on the Federal Register right here and right now. We have the list. This is the first of what I suspect could be hundreds of thousands, if not millions of Americans getting their Second Amendment rights back over the next several years. But again, you have to start somewhere, and part of that includes publishing the names in the Federal Register, which is happening right now. Let's break down what this means for your rights when we come back. Hey folks, I'm Mark Smith, host of The Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, this is huge news. This is something we've been explaining for the last several weeks, and now it's absolutely 100% coming through in a very public way. And remember, this is the precedent that is being set to in turn be used for hundreds of thousands of Americans, if not millions of Americans, to have their Second Amendment rights restored. Because remember, part of the Second Amendment here, where we are today, is not just preserving our Second Amendment rights as we have them today. We need to advance. We need to give them extra protection. And for those of us who have had or have our Second Amendment rights unjustifiably lost or improperly removed, whatever you want to call it, part of this process of advancing the Second Amendment and restoring the Second Amendment to its proper place in American life is to restore the Second Amendment rights, the right to keep and bear arms of those individuals or to those individuals who've had them wrongly removed in various ways. Or to the extent they were properly removed at one point in time, to the extent it's no longer justified to have them lose their Second Amendment rights, they will be restored. And that is a process we've been talking about on and off again for the last couple months as one of the big steps the Trump administration is doing. And that is now occurring for the first time in literally since, I believe, the year of our Lord, like 1992 or something like this, okay? We now have a first list of individuals, American citizens, who've had their Second Amendment rights restored under federal law 18 U.S.C. 925C. This is the statute that allows for the restoration of rights, the restoration of the right to keep and bear arms for those individuals who otherwise would be prohibited people from being able to possess or use firearms. Under federal gun control law, 18 U.S.C. 922G. Because remember, 922G lists the prohibited people and the things that you can do that will get you to lose your right to keep and bear arms. And under that same Gun Control Act, 18 U.S.C. 925C allows for the federal government to restore the rights of those individuals that have otherwise lost their rights under 922G. Now, of course, as we've explained before, since 1992, the law and order conservatives, law and order Republicans in Congress, and the anti-gun Democrats in Congress have combined together since 1992 to specifically write into their budget laws every year since 1992 that the ATF is not allowed to spend a dime on restoring Second Amendment rights pursuant to 18 U.S.C. 925C. To get around that, the Trump administration proactively, and I emphasize this, they proactively did this. They altered the dynamic. They pulled the authority to restore rights away from those individuals, away from the ATF, and gave the right to restore rights or the power to restore rights back to the Attorney General, in this case herself, Pam Bondi, and her team. Because they pulled the authority to restore rights away from the ATF, that long-standing congressional budget rider that's been in existence from 1992 through today was circumvented, was gotten around, if you will. Why? Because that budget rider said specifically that the ATF was not allowed to restore rights or spend money to restore rights of American citizens. But it had nothing to say about the rest of the Department of Justice, including the Attorney General herself. As a consequence, when Pam Bondi, the Attorney General, pulled the authority to restore rights away from the ATF, it got the Department of Justice away from that restriction. And as a consequence, the Department of Justice, to fulfill its promise of doing whatever it could do to fulfill and restore our Second Amendment rights, has started the process because now they can legally do so because they're not restricted by the ATF regulation imposed by Congress dealing with how to spend money. Because the Department of Justice can spend money on restoring rights of individuals, including their Second Amendment rights, and that is exactly what has now occurred. So specifically, as I've explained to you before, to have the rights restored, in addition to complying with 18 U.S.C. 925, at the end of the process, the Attorney General of the United States has to publish on the Federal Register the list of individuals who have their rights restored. So everyone now knows, let's say, that Bob or Bill or Mark have their Second Amendment rights restored because it's published in the Federal Register. There's a written document by the federal government that says they're no longer a prohibited person. And that's exactly what has just occurred, that Pam Bondi's Attorney General has just posted the first 10 people that have had their rights restored. And this, I can assure you, is the start. This is not the end of the story. This is the very, very, very beginning of the story. This is the precedent that's being set. Because remember how I've explained to you, legal maneuvers like this, such as publishing these names in the Federal Register after the process of restoring rights has occurred, that is a precedent. It is a brick in the wall. One brick that we can put in front of our Second Amendment rights. And this will be the first brick of what I suspect will be many, many bricks to restore the rights of American citizens. So let's turn to this document just published now by the Department of Justice and Pam Bondi dealing with the restoration of rights, which is what we've been talking about and predicting in extreme detail for the last month or so, and it is clearly coming true. And here's the proof right here and right now. I will put a link to this in the description, so you can check it out yourself. But this is the Department of Justice has just published this on the Federal Register. It's officially going to be published on April 29th. That's Tuesday, tomorrow. And this document is entitled, Granting of Relief, Federal Firearms Privileges. The agency is the Department of Justice, and the action is entitled, The Notice of Granting Restoration of Federal Firearms Privileges. Now, as to whether or not they should have used the word privilege there or rights, that's a separate question. I suspect they had to use the word privileges there to be consistent with the statute. But personally, if I were writing this, if I could have done so, I'm not sure I would have used the word privileges, but I suspect they did so because, remember, they want to comply with all the laws, so some anti-gun judge somewhere cannot come back and say, no, the process was not done right. Those restoration of rights never really occurred, because one of the big games that occurs here, as you've seen in other contexts, is that anti-Trump, anti-American judges, in my view, will look for legal loopholes to try to thwart the Trump agenda. So I suspect that when this document was drafted, they wanted to make sure every single T was crossed and I was dotted so that no anti-Trump judge could somehow enjoin this, could thwart this, could say, no, you cannot restore the Second Amendment rights. So I'm sure that every single dot here, every single period here is in there specifically designed to thwart some anti-Trump, anti-gun judge out there from undoing this. So just keep that in mind as I read this. I'm sure this is in there to specifically deal with those crazy judges that they've been dealing with on a daily basis in all sorts of contexts, and they want to make sure they can fight through a situation where some judge tries to challenge this. So let's carry on. This is what the summary of this public document from the Department of Justice says, and this is the law. This is the Federal Register. This is an official regulation. It's an official law, and this is what the summary says. Specifically, it says, Summary. The Attorney General has granted relief from disabilities imposed by federal laws with respect to certain individuals regarding the acquisition, receipt, transfer, shipment, transportation, or possession of firearms or ammunition. So that's the summary of this document. But what exactly does the document say? Here's what it says specifically. Supplementary information. The Attorney General is responsible for enforcing the provisions of the Gun Control Act of 1968, the GCA, 18 U.S.C. Chapter 44, Section 922G of the Gun Control Act prohibits certain prohibits certain persons from shipping or transporting, quote, in interstate or foreign commerce or possessing in or affecting commerce any firearm or ammunition, or to receiving any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. So again, it's setting up the framework here. It's saying that you have prohibited people under 922G. But then this document by the Attorney General Pam Bondi goes on to explain, but notwithstanding the fact you have prohibited people under 922G, the Attorney General has the authority to restore rights of individuals as appropriate. Here's what it says. Section 925C of the Gun Control Act provides that a person who is prohibited under Section 922G may make application to the Attorney General to remove the firearms disabilities, quote, if it is established to the Attorney General's satisfaction that the circumstances regarding the disability and the applicant's record and reputation are such that the applicant will not be likely to act in a manner dangerous to public safety, and that the granting of relief would not be contrary to public interest. Close quote. It goes on to say that Section 925C also provides that whenever the Attorney General of the United States grants relief to any person pursuant to this section, she shall promptly publish in the Federal Register notice of any such action together with the reasons therefor. So again, you see what's happening here is that the Attorney General of the United States, Pam Bondi, is tracking carefully the statutory language put down by Congress so that, again, if there's ever a legal challenge by some anti-Trump judge to some of this stuff or some anti-gun group, they follow the law to the T. That's why I think you're seeing some of this language that you and I might write it differently if we were writing on a blank slate, tabula rasa, but they're not. Pam Bondi, the Attorney General, is tracking congressional statutory law for a reason to make sure it's bulletproof, pardon the pun, from any kind of judicial attempt to usurp and take away these rights from individuals. The document goes on to address the specific individuals who've had their rights restored. The Attorney General of the United States has reviewed all the relevant facts for each individual listed below, including the materials that each individual submitted, seeking either a pardon or relief from federal firearms disabilities. And it is established to her satisfaction that each individual will not be likely to act in a manner dangerous to public safety, and that the granting of the relief to each individual would not be contrary to the public interest. Accordingly, on March 31st, 2025, the Attorney General granted relief from federal firearms disabilities to these individuals pursuant to Section 925C. It then lists about 10 or 12 individuals, and this document is then signed by Todd Blanche, the Deputy Attorney General, and it's going to be published on April 29th, 2025. Fantastic, fantastic. This is the precedent that we've been waiting for. For those of you that have had your rights lost over the years, you now have a process that actually is available. Now, that doesn't mean you're going to win, you're going to get your rights restored. I can't speak to that. You have your own lawyers. You should get your own lawyers. You should get your own guidance. But I suspect as this process plays out, the criteria and what they're looking for will become more apparent. Now, there's statutory criteria we've gone over. And I also have some I will make one additional thought about this. And I don't quite know how this plays out in the real world because I'm not inside the administration. I don't work for the White House. I don't work for the Department of Justice. So I don't know exactly what they're thinking. But what I would be thinking if I were in a position of authority in the government on this issue, in the back of my mind, I would be saying to myself, if an individual was convicted of a crime analogous to what Martha Stewart was convicted of, lying to the FBI, what Brian Range was convicted of, that misdemeanor food stamp crime 30 years ago in Pennsylvania that was a misdemeanor that technically is elevated to a federal felony under the definition of felony for the Gun Control Act. if I were in the position of authority, I would be saying to myself, if the original offense that triggered the prohibition of the person losing their Second Amendment rights under 18 U.S.C. 922G, if that original act, that original offense, whatever it was simply not a basis to lose their rights in the first instance because they're nonviolent. It was no finding of dangerousness. There was no finding of violence. There was no suggestion there was dangerous to themselves or to others. Then those would be moved to the front of the line because I'd be like, well, there was never a basis to deprive them of their Second Amendment rights under the Constitution to begin with. Because while I'm explaining to you they're tracking federal statutory law, there is another law that overlies all this, that overlays all of this, and that is the Constitution itself, including our Second Amendment rights. Now, I suspect that they're not going to get into this in writing because they don't want to do anything that's going to give an anti-gun judge an angle to mess this process up. But with that said, I would be thinking about the Second Amendment and the precedent set by the United States Court of Appeals for the Third Circuit in the Brian Range versus Merrick Garland now Bondi case. And I would be applying that. And again, I would also be thinking about the U.S. Supreme Court decision Rahimi that says that even if you are found by a court to be a current threat of violence, a current danger to another person, you can only be temporarily disarmed. So I would be keeping those precedents in mind as I was going through the people that have applied for the restoration of rights. I also want to note that what's interesting is that this document, if you look at it, it doesn't just refer to 18 U.S.C. 925C. And I don't know for those practitioners out there that are looking at this, it also makes reference to pardons. If specifically it says that the Attorney General has considered the various materials, including the materials that each individual submitted seeking, listen carefully if you're a practitioner, materials that each individual submitted seeking either a pardon or disjunctive, not conjunctive, disjunctive, or relief from federal firearms disabilities, which of course refers presumably to that statute 18 U.S.C. 925C. So the reason why I bring this up is it looks like that they're considering information submitted to the pardon office for people to get pardons or clemency from the White House, while they're also looking for people that have submitted information pursuant to 18 U.S.C. 925C. Now, I don't quite know how that works out in the real world because I don't practice in this area. I don't represent clients to get their rights restored. So I don't know kind of exactly how you do this, but it's pretty apparent. You should be aware there's kind of two avenues here that may ultimately touch fingers in the Attorney General's office as they're deciding specific cases. But again, that's going to be up to people that do this for a living and represent clients and whatnot. I will just report is if I get any information, I'll try to relay it to everyone. But again, something you should keep in mind if you're actually out there trying to accomplish this on behalf of clients or whatnot. So anyway, there you have it, folks. Hope you learned something here today. This is great news because of further evidence the Trump administration is advancing our Second Amendment rights, not just trying to hold the line against the anti-gunners, but trying to push forward and expand the Second Amendment in America as well as they should be doing. They promised to do it, and I think they're doing it. And it's only been 100 days, so there's a lot more good stuff to come, I suspect, over the next 3+ years. So there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxandr. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.